we have Ms. Madeline Kimei from Tanzania. We are honored to welcome Ms. Madeline Kimei, a leading dispute resolution and arbitration practitioner based in Dar es Salaam, with over 15 years of experience in high-value commercial disputes. She's the founder of iResolve and currently serves her second term as president of the Tanzania Institute of Arbitrators. In 2025, she joined 3 Vernulum Buildings, UK, as an associate member and has been appointed to prestigious panels including ICSID, SIAC, LCIA, SHAAC, and ICANNS, our IRP panel. Her expertise spans sectors such as construction, mining, telecom, and finance, and she's widely recognized for her contribution to ADR policy, training, and innovation. We are privileged to welcome Ms. Madeline Kimei to share her insights on the ADR landscape in Tanzania and to enrich today's proceeding with a global perspective and leadership. Over to you, madam.
Thank you so much, Kovise, and thank you to the Global South ADR Day. The entire team, this has been quite a wonderful day, and thank you for sharing all these insightful experiences from the different jurisdictions within the Global South and beyond. My name is Madeline, and thank you for introducing me once again. For this presentation, I will project my slide. I hope with the nod, you can see the presentation in front of you. Thank you. Now, I've been asked to speak about arbitration in Tanzania, and it's really at a pivotal time in Tanzania and for Tanzanian arbitration, for the arbitration landscape in Tanzania. Just as an outline, I will touch on with an overview of the legal framework on arbitration in Tanzania, and I'll swiftly move to speak about the different ADR institutions that have been accredited and currently having a major impact on the arbitration landscape. I will then also touch on a few prominent cases that have raised eyebrows within the arbitration community in Tanzania, and of course, within the neighboring region. And then, of course, item number 4 on my outline will touch on the future or predictions, I would say, on legal reforms within Tanzania. And then I will conclude on my presentation. Okay. On this next slide, I have attempted to give you a roadmap. And so within that roadmap, you would note that we had a prior enactment that was on arbitration. It was based on a very archaic law from the English Arbitration Act of about 1882, if I recall correctly. Now that 1887 it was, apologies, the Arbitration Act Ordinance of 1887. The first Arbitration Act in Tanzania was enacted in 1932 under Chapter 15 of the laws of the United Republic of Tanzania. That particular legislation had only 32 parts to it, 32 sections that were to guide in brief the arbitration process in the country. With those 32 sections, in 1957, we saw introduction to arbitration rules. And these rules were passed through Government Notice 427 in 1957, which somehow outlined further certain procedural rules on arbitration that supplemented the main legislative piece, which was enacted in 1932. That piece of legislation remained unchanged up until a few amendments were made in 1971. And prior to 1971, I think it's very notable to note that a few changes occurred on the Civil Procedure Code. Now, the Civil Procedure Code, through its section 64, introduced the multi-door concept, the doors of the court being able to open up to other mechanisms that were being offered out of the court or within the court. And one of those mechanisms were arbitration and mediation. And this was not new during that time, due to the influence that we had from other common law jurisdictions, such as the United States. Now, moving on and jumping out of the CPC, which is the Civil Procedure Code, and it's pretty much modeled and mirrors that of the Indian CPC, save for a few tweaks here and there. I move on now to the amendments that were done in 1994, which really now cemented the concept of a multi-door courthouse within our judiciary. And this was the entire judiciary having to have a mandatory court-annexed mediation program under that GN, which is the Government Notice 422. Along with this amendment in 1994, interestingly, there was a schedule stuck at the very back of the CPC that spoke on arbitration and provided for a much more lucid sort of approach on assisting parties in arbitral matters on that era. And in 2000, our constitution, although it had already embedded a mandatory provision on our judiciary to ensure that they promote the use of dispute resolution, was enhanced through Article 107, subsection 2, D and E of the United Republic of Tanzania Constitution. And so our foundation to ADR is found within the constitution of the country. Now, throughout that period, and this is a very interesting time for arbitration in the country, because during that time, from the 1932 enactment of the mother law of arbitration in the country up to the end of 2019, there had been no changes to the Arbitration Act at all, no major changes at all. It remained with its 32 parts and the rules that were supplemental rules. And so much of the work was done by the courts. The courts of law were pro-arbitration and very proactive in applying the foundational principles of arbitration throughout this journey that we've had to go through with a very archaic, very rigid Arbitration Act. And so during that time as well, I think it's something interesting to note that there was efforts by the Law Reform Commission since 2012 under a BEST program, and this is doing business program that was funded by, I think it was World Bank, if I'm not mistaken, to conduct a study on the usage of this mechanism in the country. And through that program, there was a report, there was a need for a new bill, and through the Tanganyika Law Society, we did see a draft arbitration bill that was modeled along the lines of the UNICITRA model law on international arbitration. But we didn't see this coming up. It was lying somewhere on someone's desk for quite a while, up until 2017, late 2017, when we started seeing that the legislature was now interested in putting up a draft that was going to be called Arbitration and Conciliation Act, and called for stakeholder comments. However, in 2017, nothing happened. Then in 2019, we had a second round of Bango Kitita, which is the stakeholder comments. We call it Bango Kitita. Now, that Bango Kitita resulted to the 2020 Arbitration Act. And you can see through that roadmap that we had another amendment after the enactment of the first version of the 2020 Act, an updated version in April 2021, which is now the one that is currently in play in the country. Now, throughout this legislative reform, seeing this new enactment, which has provided the country with a much more coherent arbitration framework, we also saw some changes around international arbitration or investor-state arbitration policies within the country. We saw the enactment of the Natural Wealth and Resources Contracts, which was the Review and Renegotiation of Unconscionable Terms Act 2017, telling us whenever there is a dispute, let's look into what means is best to resolve that dispute that involves natural wealth and resources. Should we keep it in country, or should we have it resolved in foreign tribunals? And so the first enactment in 2017 restricted access to foreign tribunals when it was dealing with disputes arising from natural wealth and resources. However, there was a little bit of a backstepping in 2020 where we saw that particular legislative piece revisit that provision and reintroduce the fact that arbitral tribunals or tribunals that are foreign tribunals can still be approached in terms of administration of those matters. And so therefore we've done a 360 there, and we are at a good standing. In the Public-Private Partnership Act, we also saw a similar provision in 2018, and that was also amended in 2023, recirculating back and recognizing that there are these tribunals such as the ICSID and tribunals recognized under different PITs and MITs that the country has signed up to. Now, the confusion comes back then in the most recent changes to the Tanzania Investment Act. Now, the Tanzania Investment Act in 2022 was amended and refurbished in a way that it included the provisions of resolving the dispute and referring a matter to the ICSID. However, we've seen the new act that deals and regulates investments, FTIs and the rest investment coming into the country, and special economic zones, now it's called TISEZA, sort of go away from that particular framework and has introduced other tiered processes such as negotiation, and failing such negotiation, arbitration, yes, but arbitration in accordance to the agreement that the parties, the state, have between each other, and not specifically mentioning the ICSID or any other recognized foreign tribunal that would handle such cases. And so we've seen a shift away in that 2025 legislation. If I move on to the next slide, and I'll speak much more on the Arbitration Act and the great innovations that parties are afforded under this particular act. This act was really done in a way that it somehow mirrors, to a certain extent, the UK Arbitration Act of 1996. And so we did not go the purely sort of pure approach to the UNICITRAL model law. We borrowed leaf from the innovations of the UK Arbitration Act, introducing provisions such as the serious irregularities, challenges on serious irregularities that is in the section 68 of the UK Arbitration Act, introducing the stay of proceedings under section 15, which provides for a mandatory stay unless the court is satisfied that the arbitration agreement is null and void or inoperative or incapable of being performed. And so we've seen these provisions work very well, despite the fact that we do have an infancy within this procedure or in conducting this procedure in the country. And when I say we're at the infancy stage, it's because this act has been well explored in the UK. It's been around since 1996, so they've had the test of time with it. But for Tanzanians, this is a new creature altogether, introducing new concepts, such as the competes rule, where it gives mandate to the tribunal to to provide a ruling on its own jurisdiction. And this has been codified under Section 34 of the Act. Another new innovation for us, it's an innovation, is the costs follow the event under Section 63, 64 of the Act, which is Part 8 of the legislation. This now has given us a codified costs shall follow the event principle, where now parties are able to rely on if the rules maybe do not provide, the arbitral rules that they are working with do not provide such avenue. And so we've seen great innovations and of course, yes, alignment to the UK Arbitration Act, but also certain other provisions which go away from the UK Arbitration Act and provides for much more local perspective, such as the introduction of the Tanzania Arbitration Center under Section 82 of the Act. Also, Tanzania takes a different approach by adapting the New York Convention, not in a separate legislation, but within the enactment itself under Section 78. Usually you would find such provisions that adapt the New York Convention in a separate legislative piece. Usually you would also find establishment of centers, national centers, in separate national legislations. However, this is embedded into one big statute that has about 101 sections to it. Most importantly, of course, the Arbitration Act in play covers both domestic and international arbitration. It provides for arbitration agreements that which have not been signed because of that broad definition that is provided for within the legislation. I'll move back to the principles under Section 5, which are very important to sort of shed light on, because these go at par with international standards, at par as to what we've seen in the other presentations that have come before me. Section 5 of the Act provides for the general principles, and the general principles echo throughout the corners of many jurisdictions, and one, to have fair resolution of disputes by an impartial tribunal and avoidance at all times if unnecessary delay or unnecessary expenses to the parties. The other principle, which is the freedom of choice, which is the party autonomy principle that we all are sort of embracing to ensure that parties have that option, have that freedom to choose the procedure, to choose the appointment of the arbitrator that they wish to engage in their matter. The minimal court intervention also, we will see when I'm speaking on the cases. I did jump a slide, and I didn't jump it by mistake. I wanted to go back and forth in saying that the Arbitration Act covers also international arbitration. And Tanzania is not an island. We have been a member or have ratified the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards since 1964. And in 1992, we signed the ITID Convention. It was then reflected within the national law of the Tanzania Investment Act, as I spoke of earlier, which has now been removed due to the recent enactment of the Tanzania Investment Special Economic Zones Act 2025. Now, we'll speak more on that in a later slide. We are a regionally based country in the East African community, and so there are other provisions such as the East African Court of Justice, which offers arbitration rules 2012, and so there's an avenue there to access arbitration. The South African Development Community as well, the SADC region, having that Tanzania has been a member since December 2020. And within the SADC region, there is an arbitral institution under the AFSA SADC division, which was launched with the SADC panel of international commercial arbitrators. We also have a new continental-wide free trade agreement, which is the AFCFTA, and we'll see its impact in my later slide. Tanzania has also signed about 20 BITs, 9 remain to be enforced, and 11 are not enforced. In late 2019 or 2018, we did see Tanzania serve its notice of intention to terminate the Netherlands BIT. There was also word of a termination of the Canadian BIT, and so on and so forth. So there is this a pullback of this particular model of BITs, as we've seen conversations happen in different doors with regards to these BITs, and a shift towards the MIAs as opposed to BITs. Now, in terms of implementation of the Act, it's really growing because of the support and the level of support we see from the government stakeholders. And there's a clear policy direction now, despite the fact that there is no ADR policy in play. Now, the Act itself applied retrospectively. And so under Section 96, it had retrospective effect, and that did affect the arbitrations that were pending at that time when it came into effect in January 2021. The enactment is not supported by any court procedural rules. This is still not yet in place, although there is room under Section 95, subsection 3, for the Chief Justice to put up rules that will complement the execution of this particular piece of legislation. However, this is still on the pipeline, and because it's still on the pipeline, there are a lot of challenges faced by practitioners on the ground in channeling their arbitration-related matters in the courts of law. There are no practice notes or guides at the current moment. However, we are guided heavily by the precedents that comes from the English court, because our Act is a mirroring effect, as I said earlier. In terms of arbitral institutions, I will speak on this at much more length in another slide. However, we do have arbitral institutions, and they are recognized under the legislative piece and given certain immunities to the extent that they can act in good faith. The arbitration practice itself requires for one to be accredited. And why accreditation? Accreditation, of course, is mandatory in Tanzania for both local and foreign neutrals. Accreditation, of course, is advantageous if we speak to the fact that we will have a set benchmark on the standards required within the practice. We'll have a set benchmark on the aspirations that we want to achieve in terms of public confidence in arbitration. And then, of course, there's that need for consistency of the movement towards now introducing that reliability by the public of this particular service stream. Now, as professionals, we are charged, it will be a penal offense if we act as arbitrators, mediators, or adjudicators without being properly recognized and having an accreditation certificate in place for you to be able to practice. And so that's the slide that is in front of you. Along with that regulation that requires accreditation, there's also another regulation that requires one who practices to follow certain codes of conduct and practice. And that code of conduct and practice outlines rules such as the disclosure of conflict of interests, confidentiality, the need to ensure quality of process, maintaining impartiality, and of course, availability and dedication, and having competence to perform the tasks that have been trusted to you by the parties. Arbitral institutions in the country keep growing. The number keep growing. Just more recently, about 2 weeks ago, there has been a new entrance to this list, which are not included in my slide yet. The Tanzania Institute of Arbitrators has been around since 1999. That's an institution where I'm currently the president. The Tanzania International Arbitration Center was established by the Tanganyika Law Society. It is based in Dar es Salaam. It is a company limited by guarantee. We have the National Construction Council. I think it's the oldest standing. It's a statutory institution and caters to the construction industry. And before, of course, the establishment of the Tanzania Institute of Arbitrators, we did see most commercial matters also go to the National Construction Council. And so the people there, the members there, saw the need now to have a separate body to administer commercial matters so that the National Construction Council can focus in on the construction matters that it was administering then. The Tanzania Arbitration Center, as I spoke of, is a creature of the statute, the Arbitration Act, Cap 15, revised edition 2020, under Section 82. And its headquarters are meant to be in Arusha, but what I believe is that they will they will change that soon through the reforms that I will speak to be in Dar es Salaam. And this is a multidisciplinary
There was some issue with Madeline's connection. She's rejoining. Yeah. Madeline, you have to unmute your audio.
Thank you. Apologies for that. My internet might have gone a little bit lower in data. Apologies. So the Tanzania Institute of Arbitrators, as we've already come to know through this presentation, was launched by the previous Honorable Chief Justice of Tanzania in 1999. And at this point in time, when I'm speaking to you, the membership keeps upwards, keeps going upwards, with 343 members in 3 different categories, having fellows, members, and associates. We have some international members coming in from Kenya, Tanzania, Uganda. By gender, we have about 239 male and 104 female members. And so it is a growing institution. It has a set of rules for arbitration and a set of rules for mediation, both modeled along the lines of the UNICITRAL model rules on arbitration and/or mediation. At the current state for this year, it's holding a total value of disputes amounting up to 10 billion United States dollars. And so it is a very much growing exponential institution in the country that needs to be well recognized for its efforts in ensuring that there's consistency, there's a legitimacy in the process within the domestic landscape for arbitration, because most of these disputes are domestic arbitrations as opposed to international arbitration under the Tanzania Institute of Arbitrators. Now, moving on to our courts and how our courts have continued to embrace arbitration. Our courts have continued to embrace arbitration in many aspects. I've just put down a couple of aspects on my slide where you've seen the courts echo the courts in many other jurisdictions, that it is not an appellate court. Matters that have been put forward in a arbitral tribunal have been fully adjudicated. And when you go off to court to challenge an award in any sort of manner, the courts are not to revisit that as if it's appreciating the evidence before, which have been already adjudicated by an arbitral tribunal. So we see that in the Marine Services case. We see that also in the KFCRI International Engineering case versus the University of Dar es Salaam, a 2020 decision where an award that infringes public procurement law or policy, that illegality may be sufficiently relied upon to set up aside an award. This is in conformity with most of the jurisdictions that have adopted the New York Convention on the Enforcement of Arbitral Foreign Awards. The public policy provision also was touched on in the Vodacom and Planetel case, where you see that the court held the award to have been procured in a manner that is contrary to public policy. The same is uncertain and unambiguous, they say. And then it proceeded on to say these are serious irregularities affecting the award and remitted it back to the tribunal for reconsideration pursuant to Section 75 of the Act. In KFCRI, further also, in the same case that I have already sort of put up in my first bullet point, I think that was just a repetition, that was also on the public policy provision and the application thereof by the Tanzanian courts, and how it can eat into the final award and set it aside or remittance back to an arbitral tribunal for reconsideration. On the issue of serious irregularities, a lot of cases are taking this route in the court for purposes of challenging an award, and we've seen an avalanche of these cases. The court keeps, of course, the same principles that one does not revisit these awards and serious irregularities, holds a high threshold for you to prove that award is tarnished, and it has these aspects spanning from it, and so it should be set aside. One such example may be a 2023 decision is the CSI electrical case, where the unilateral communication of the award by the institution that was administering that arbitration was seen to be a serious irregularity. And so what happened there was that the institution was seen to have communicated the award to one party without having done so to the other, communicated to the other that award has already been filed with the institution for purposes of now delivering it to the parties. And so that unilateral communication was seen as a serious irregularity. Another very recent case for, I think, is the Tarura and Canopies case. As you can see there, this gave a clear path to practitioners on the dilemma that we had on post-award enforcement procedures. The post-award enforcement procedures to date have not been put up very well in our legislation. And so we're going back and forth between the Act and a set of regulations that were really meant to be rules that can be adapted for the procedure, ad hoc procedures on arbitration where parties have not agreed to a set of rules. These regulations were to be opted on by parties. But then within those regulations, we saw that they had provisions for filing and recognizing an award. And so participants or practitioners would run off to court using those regulations. And so the Tarura and Canopies case really closes the gap, the procedural gap, as you can see there on my slide, as to the filing, recognition, and enforcement of a foreign arbitral award. Now, in terms of ITSID awards, we still don't have a clear roadmap in our legislation that puts together a self-contained framework for ICSID awards. And the Arbitration Act, that the current one, which is in force, has no specific provisions for the enforcement of ICSID arbitral awards to date. And so this route may be within the reform basket of the Law Reform Commission, but not very solid at this point in time that we will have such provision. Now, moving on to my, and I hope I still have time, to the future, and I'll touch on this very quickly. The future, what we see in Tanzania and the landscape for ADR is that we will have some sort of a refinement of this regime in Tanzania, where we will have an introduction to an ADR policy that directs us as to where the country wants to go in strengthening the environment for ADR in the country. We will hopefully see court procedural rules that enables parties to take arbitration applications, matters within the court, and those rules to set clear timelines, because at this moment in time, those timelines are faded. And so that in itself creates a lot of havoc for this particular framework to work well, because it is a lucid, coherent enactment, but it won't work well without these other foundations around it, holding it up. Reforming the new act, we've had it since 2021. It came into force in January, early January. Yes, we're revisiting certain provisions that we've seen that are a little bit challenging to implement, such as the Tanzania Arbitration Center, which has not yet become operationalized. Its provisions appear on several parts of the Act. I think it appears 31 times on the Act. It acts as a third-party appointer. But because it's not operationalized, that means within these 4 years, we've had a lot of challenges, removing an arbitrator, reappointing or replacing an arbitrator, because it's that power within the Act is vested with the TAC. And the TAC is not operationalized yet for 4 years. And so you find persons really looking for this center to be maybe provided with wider definition to include other arbitral institutions in the country, to include other institutions such as the Tanzania International Arbitration Center, such as the Tanzania Institute for Arbitrators, to also have mandate and the whip to replace, the whip to appoint, and the other 31 times mandates provided to the center, being supported by the other accredited institutions in the country. We've also heard of reforms that are being discussed at the UNICITRAL on electronic awards. And so this is the work that is ongoing within the UNICITRAL working committees. And so therefore we do envision that these enactments or these reforms may consider further appreciating electronic awards and having a focus on increasing the accessibility of technology, because already the Act does provide for electronic signatures. It does provide for other use of technologies. And so therefore we're seeing that it might go the direction of even recognizing electronic awards. And so that is a space of digital innovation within arbitration that we look forward to. Another future prediction for Tanzania is the enactment of mediation regulations. We've seen the Indian legislature put up a wonderful piece on mediation, and that really has inspired us in order to ensure that mediation picks up pace. At this moment in time, as I'm speaking, since the introduction of the Tanzania Institute of Arbitrators mediation rules in 2022, we've only seen and administered 2 matters on mediation. I think that number is extremely low, and it's extremely an important, a critical matter at this point in time in my presidency as well, that we put a little bit more energy towards ensuring that we have a conducive legislative or regulation that gives mediation a pickup for Tanzania, and of course for the region at large, and for the global initiative under the Singapore Convention to also be recognized within the Tanzanian jurisdiction. In the country, we use adjudication, construction adjudication, and it is very, very, very common in construction disputes. However, we don't have a statutory framework for it. And so therefore, we are also hearing within closed doors that there could be a mechanism put up to regulate this construction adjudication practice that has been around for quite a long while. Now, in terms of mediation reforms, I think I've already given you a little bit of my idea there, that we are going to see improved institutionalization of mediation through these enactments that we foresee. On the African continent, we cannot go away without speaking about the African Free Continental Trade Agreement, because here is where we will see again an avalanche of disputes arising in connection with that intertrade activity. And as the activity will be quite exponential and colossal, we will be seeing an uptake or at least an increase in disputes, commercial disputes to say, and the caseloads within institutions in our countries will pick up. And so that is a space to look out for. One, because the AFCFTA does not provide for a dispute settlement mechanism for the participants within that, within the trade area. It only provides for the states, when the states are disputing, to have a dispute settlement mechanism under Article 20 of the AFCFTA. And so it's limited to that, to those kinds of disputes. And so opens up arbitral institutions to handle those other commercial disputes between the players that would be within that trade area. More on future predictions. On my slide, I think we've touched on accreditation. Accreditation won't go anywhere, but we look to ensure that it's streamlined, standards are set, borrowing leave from jurisdictions that have put up such a framework of accreditation. We have seen an increase in third-party funding. We have an award against Tanzania under the IDSID, the Nachingwea Award. Was also the claimant there was third-party funded, and so therefore that increase in interest by Tanzanians might see that the legislative piece, when it does go through its reforms, introduces some sort of a policy direction in terms of third-party funding recognition in the country. We are a common law country, and so the rules of charpentry do apply. And so we will see how we will take this particular TPF provision forward. Will we borrow leave from the English, from the Singaporeans, from India? I'm really not sure at this stage, because the comments have just been tabled before the Law Reform Commission. Award review mechanisms. This is, I think, was also presented by our Nigerian colleagues under their new legislation. We've seen an award review mechanism being introduced in several other jurisdictions as well, offering that appellate level of that particular award within either the institution administering it or otherwise. And so therefore, these are things that we are anticipating in the near future. I'm very thankful once again to the Global South ADR Initiative 2025 by Kovise and the many other colleagues that have supported this event. I have done and conducted a survey this year, ADR usage by Tanzanian businesses survey. And this survey was very interesting. And I think the interesting part is that it wasn't surprising because 26.67 have none at all encountered ADR out of the persons that have responded. There were 60 respondents. 21.67 said that they had little knowledge of these mechanisms. And so the data speaks volumes on the level of know-how or the level of awareness, the sensitization that has been done at what level at this stage in time in 2025 for one African country. But I think it speaks to the rest as well, because the knowledge still needs to be amplified. More knowledge to Tanzanians, more knowledge to the East African community at large. So in my conclusion, I would say then the capacity building strategies are at the top rank of my agenda. That is to play a greater role in practice-oriented think tanks and innovative efforts. To provide virtual learning modules such as this Global South ADR initiative, which I fully support because this cuts costs. And so we wouldn't hear about the issue of costs in getting this knowledge. It really does give anyone reach to this information that is crucial in building up a culture of alternative dispute resolution enthusiasts. And so with that note, I thank you once again, and I am very much open to discussing further my presentation. I hope I was on time, but I really do think I was beyond time. Thank you.
Thank you, Madeline. It was a wholesome narration about the scenario in Tanzania. As expected, you have just performed to the maximum what I can imagine. And Tanzania is going to be a very interesting ecosystem when it comes to arbitration and future mediation. Due to paucity of time, I couldn't further stretch this. Because already the next speaker, Ms. Alex Murley from Mauritius, is available. Thank you, Madeline, for sparing your valuable time, sharing the thoughts about arbitration in Tanzania. Thank you.
Thank you very much, Inbav. Thank you.